Well, good afternoon. It's my pleasure to welcome you to this special event hosted by the R Street Institute. My name is Brandon Pugh. I'm the director of R Street's Cybersecurity and Emerging Threats team, which leads our data privacy and our data security work. For those of you that are not familiar with us, the R Street Institute is a nonprofit, nonpartisan public policy research organization. Our mission is to engage in policy research and outreach to promote free markets and limited effective government. A key focus area of our team is passing a federal comprehensive data privacy and security law. We believe such a law would benefit consumers, industry, and security. Today's event will explore the intersection of privacy and law enforcement. We believe it is important to balance the needs of law enforcement with individual privacy. In the bipartisan, bicameral data privacy and security legislation last Congress, the American Data Privacy and Protection Act, or ADPPA, or ADPPA, however you'd like to say it, we saw this balance discussed. Our panel of distinguished experts from different backgrounds will explore this, along with broader implications, with an opportunity for question and answer at the end. To start our panel, I'm happy to introduce our moderator, Stephen Ward. Stephen is a data privacy and security fellow at R Street, but beforehand, he spent about a decade in law enforcement, and he held roles with the Federal Trade Commission, or the FTC, and at a tech startup. So thank you, Stephen, for moderating today.
Thanks, Brandon. And good afternoon to everyone. First, as Brandon mentioned, I do want to encourage the audience to submit questions, and we will leave time towards the end for a Q&A. And I am honored to introduce an incredible group of experts, and starting in no particular order, Teresa Hadigi is the Chief Legal Officer of the National Child Protection Task Force, an organization dedicated to assisting law enforcement in cases involving missing and exploited children. Jillian Snyder is the Policy Director of Criminal Justice and Civil Liberties at R Street Institute and is a retired New York City police officer. Woodrow Hartzog is a professor of law at Boston University School of Law. He's an author and an international privacy expert. Emiliano Falcon-Morano is the Policy Counsel for the Technology for Liberty at the ACLU of Massachusetts. And jumping right into the questions, Woody and Emiliano, you both have an extensive body of work around law enforcement and their data use practices. In one example, New York City is starting a RoboCop pilot program where a 400-pound RTD2 lookalike will reportedly be patrolling Times Square and the city's subways. Now, I do have to say, my 5-year-old son thought this RoboCop was the coolest thing ever and wanted to add it to his toy robot collection, and he was quite disappointed when I told him it was outside of our price range. But getting back on track, given the increasing use of technology and data in law enforcement investigations, what steps can be taken to ensure that data is collected and used in a responsible and ethical manner while also balancing the need for public safety?
Woody, do you want me to go, or do you want to go?
You can go first. You can go first, then I'll jump in.
Okay, thank you. So first, thanks for inviting me for being here. Thanks for the question, Steven. So I think that in this case, I have to say that I'm kind of like strongly against the use of these robot types to conduct surveillance. Just that, like as a baseline, like I don't think that law enforcement should be using robots of any kind to conduct surveillance because of many civil rights and civil liberty issues, especially concerning to how they work, how they are tested, how they are audited, how do they work, how do they move, who they target. So I think there are like many issues that are not answered because many times private companies that build these robots don't kind of like are transparent enough for the people to know what is the surveillance technology that's used against them. So in this case, what I would say is that the best data practice for this robot is for this robot not to exist. So I just wanted to say that because I really don't think that these surveillance technologies should be deployed at all, point blank.
So thank you very much, first, by the way, of having me here. I really appreciate the opportunity. And thinking about the use of robots in law enforcement, actually, when I'm in a lot of my writing, I've come out strongly against automated law enforcement robots and the use of extensive AI-driven tools as well for surveillance, and would tend to support strong rules prohibiting their use. But to get specific a little, I think it's worth thinking about 3 areas that you really would want to address, putting aside the choice to outsource law enforcement's responsibilities to technology. So I think that's a policy choice that we can put maybe somewhere else for the discussion. But the question was about how do we collect and use data in an appropriate way? And I think there are 3 things that you'd want to keep in mind. The first is, I think it's important for our rules to recognize that there is, in fact, privacy in public. One of the things that I think has been unfortunate about some of our previous rules is a general tendency to say that there's no privacy in public. If you're standing out in a public place, then you have no reasonable expectations of privacy. Now, of course, Carpenter and I think other precedents have pushed back on that, and legislation is increasingly doing that. But having some rules that take a nuanced approach and recognize that there are certain kinds of surveillance, even in public, that might be corrosive to people's privacy and that we should resist are important to have in place. The second thing I would say would be important to make sure is implemented, not just in robot police officers, but in any sort of digital technology that's using to collect information for law enforcement purposes, or for any purpose actually, is robust data minimization. The idea that you should only collect what you need and that you should delete information when you're done with it. I think that if of all the fair information practices that have made their way into privacy and surveillance law, this is my favorite and the one that I would say we need to embrace robustly. And then finally, there's the question about algorithmic decision-making and the data that's used to power that. And I have a lot of concerns about the use of technologies at scale for surveillance purposes, whether it's inside of a robot police officer or otherwise, to make sure that we have meaningful rules around algorithmic accountability. I'm particularly suspect of things like predictive policing that I think reinforces a lot of unfortunate biases and has a harmful impact on communities of color and other traditionally marginalized communities. And so I think that you have to keep at least these 3 things in mind when thinking about the deployment of automated surveillance tools, among others. We could spend an entire class, I think, on automated law enforcement technologies.
I don't know if Jill or Teresa wanted to step in on that question too. I'll give you that opportunity, or I can move on.
I don't know if Teresa has anything to say. I do, obviously, just being recently retired from the New York City Police Department. I was a little excited about some of the advancement in technology. I look at it, I live in New York, I teach at John Jay College, and I work at R Street. And I think of just the millions of people that are in the city of New York and how we don't have the resources right now, personnel-wise, to police the streets. And I do think that with proper regulation, ensuring that we are upholding individual civil liberties, I do think some of the advancements of technology and surveillance could be very fruitful in the reduction of crime. Again, I'm looking at it through a complete public safety lens, and from the law enforcement perspective, I think having and ensuring the algorithm, as you said, Woodrow, correctly, officers see things very subjectively, and if we could come up with this objective criteria in which we use the surveillance, I think it's fairer, can reduce some of those disparities you were mentioning.
So yeah, can I chime in there so I think that there is a mistake when we see technology or like automated systems as being objective, right? Because there are people behind these systems, people that either write the code, people that either choose which data these systems should be trained on. So I think that calling these systems objective might give people, especially like lay people, right, the communities, that we all want them to be safe and we want them to be free, right? So I feel that if we tell them that this is objective, then it becomes something like it's like that just because the computer says so, right? And sometimes the computer gets things wrong. For example, with facial recognition technology, we have seen so far 5 Black men that were arrested, one of them in front of their kids because of a mistake in the facial recognition software. So I think, and I'm sure that the people that were using the technology were like, oh, well, this is an objective system, so the system output was this person, so the system must be correct. And we actually have to train, especially law enforcement officers and public safety people, to understand these kind of like nuances with the systems and how these systems are not always correct because they are not possibly objective, because they were trained and they were created by humans who we know we are not objective, right? I just wanted to like chime in and kind of like add kind of like a layer of nuance to what objective mean. Yes, there are ways where we can try and make automated systems be more accurate, but I don't think that they will ever be objective, right? In the way that we use that term. We have been saying that with like things like that ChatGPT kind of like hallucinating, right? And like making up this case law and making up all this information. So I think we should be like cautious with that. Thank you.
Yeah, thank you. Well, I'll say, Jill and Teresa, you both have worked closely with law enforcement investigations. And recently, and just as we heard from in the last question, we have heard some potential concerns and risk with data usage by law enforcement, which could lead to privacy concerns. But in your experience, what are the positive uses of data?
Go ahead, Jill.
Oh, no, if you want to go first.
Okay, sure. So what I would definitely say in regards to the utilization of data that's been collected by all of these different third parties, by social media companies, everything else along those lines, it's allowing law enforcement to start looking at cases that otherwise I would say either don't have the necessary leads in order to solve them, or alternatively, it's allowing them to look at new cases in a different sort of light. So there are a number of cold cases that have existed in which there are individuals who have been subject to very serious crimes, and there hasn't been a whole lot of progress in regards to that. By being able to review those cases under the guidance of more data that's been available in those instances, it is allowing law enforcement to sort of revisit those and be able to get some additional leads. The other thing that I think is really important that we don't necessarily talk about as much is the exculpatory benefits of utilizing a lot of the data. When data collection, when we are law enforcement as a general, when they're reaching out and looking for data specifically from these various different companies, and they're using it for not only the narrowly tailored purpose, but they're using it for inculpatory and exculpatory purposes, the best thing that I can give you an example of is Google geofencing, which is for a lot of different people becoming a more widely recognized tactic. However, that can be a really wonderful way to sort of review how that data can be used to either exclude or include various different suspects and be considered for a number of different purposes. The other thing I'm going to say is that when it comes to instances of missing individuals, specifically in regards to missing children, data surrounding various different identifying information, device identification, near field communications, a lot of that information can be utilized to go and track down where these individuals are. And so regardless of whether it is a child who's gone missing or if it's an adult who's gone missing, given the fact that I think it's something along the lines that 98% of individuals within the United States have some sort of cell phone and or smartphone, that level of near field communication can be a huge boon for a number of different law enforcement organizations.
And just to add to what Teresa was saying, particularly around missing children, I think the last data from 2021 shows that individuals or children reported to the National Center for Missing and Exploited Children, they had almost a 90% being returned. That's astronomical, and that is really with the reliance that they use on this data working with law enforcement. I used it in my professional experience. We would use social media and the information that we could derive from there, often in investigating situations. It wasn't just cops sitting around looking for people's information. There was a tip or someone alluded to something going on. So in a proactive deterring mechanism, we would use that information to detect and hopefully prevent crime.
Emiliano, Woody, do you have any thoughts on that?
Yeah, thank you. So basically, when I think about all this kind of like technologies and all the use of social media, right? I like to explain it as kind of like a house, right? So I live in a building apartment, so I have my house, and then there is like a bulletin board, right, in the lobby of my house. So basically, the Fourth Amendment, right, protects everything that's on my house, right? I try to kind of do this parallel with our digital lives, right? If we post something in Facebook, right, and our Facebook is public, well, that's public information because we decided that's public information. It's like me putting something up in the bulletin board and then law enforcement coming to my apartment and seeing that and kind of like they can take it, right? But they cannot come to my place. They cannot come to my apartment, right, without a warrant, right? So I think that there is some information that these companies collect about us that basically should be inaccessible absent a warrant or exigent circumstances, of course, because that's how we work, right? If I had those papers in my house, right, law enforcement would need a warrant. So why wouldn't they need the same for accessing that information that's in possession of the company? Well, I guess that people will say, well, because of the third party doctrine, right? Yes, but we are trying to argue in courts and kind of like everywhere is that the third party doctrine should be revisited in these digital times. And of course, there has to be a trade-off between the things, the power that we give law enforcement and what kind of like there, especially I think that the trade-off is not between privacy and security, right? Because we can be both safe and free, right? I think that's a false dichotomy. We can have privacy and we can be free, and law enforcement can do their tasks while people preserve their privacy. I think that there is an issue here with what companies can and can't do with regards to law enforcement. So I think that that's the relationship that we should be more concerned about.
Yeah, and that kind of jumps into, my segues perfectly. My next question is the potential trade-offs between personal privacy and community safety, and how can they be balanced? And I'll open that up to the panel.
But if I could, I might push back a little on the framing of the question, because whenever personal privacy gets pitted in community safety in terms of a policy debate, it's almost always going to lose. Because it seems like it's sort of an individual right that is then pitted against a sort of structural community good. And so I'd like to rethink of it as thinking about big picture versus big picture, like what is a community that has meaningful privacy that enables human flourishing have, as well as community safety. And then B, also resist a little bit the idea that privacy, like Emiliano said, that privacy and safety are in tension. I don't know if that's the case for multiple reasons. Now, of course, there might be some cases where there is, but one of the things that has become clear in researching this area is that it's a relatively complex dynamic between safety and privacy. One of which is because increased data collection also increases risk to safety, not just privacy. And so sometimes when you have a massive amount of information and are trackable wherever you go, particularly if it's done at the industry level, then that actually makes harassment significantly easier. And this is particularly true from what we're seeing with facial recognition surveillance. One of the first unfortunate uses that we've seen with widespread available facial surveillance tools is harassment and stalking of people. The more information that is collected and stored, not minimized through the data minimization principle, you also see significantly bigger fallouts when data breaches, which unfortunately are inevitable, do happen. What was the famous quote? There are two kinds of people in the world: those that know they've been hacked and those that don't. And so I think that there's a complex relationship there. The third aspect that I would just sort of layer on this discussion is that there's a world in which people share information within trusted relationships and would consider their privacy to be protected. And that's a world that I'd like to see. It's one that's actually somewhat embodied in the ADPPA with the concept of data loyalty, which is something that I've been writing about a lot. And it's the idea that privacy and safety don't have to be this sort of zero-sum game where when you get a little privacy, you lose a little safety. We could think about meaningful rules that protect privacy within relationships of trust, and how that data flows to other parties and rules that attach to it when it does. And so I'd love to see a little more conversation around that area as well, because I think that's a meaningful way forward, so that we don't have, this sort of consistent pitting of safety against your community safety against personal privacy, which I think unfortunately sets us up for not as great outcomes as we could otherwise have.
Yeah, and I would also like to thank you, Woody, for that. And I would also add that last year, like when we're talking about like how like law enforcement accesses data that's held by private companies, last year it was made public that Google had responded to fake government requests, right? Because these government requests are so easy for the government to issue and for law enforcement agencies to issue to Google that Google started receiving fake government requests, and Google didn't have any way of knowing if these requests were true or not. So they started just like giving these troves of information to all these bad actors that were pretending to be the government. And then they used this information to harass and extort minors and women and do like a lot of sexual harassment. So I think that like going to in this kind of like false dichotomy of like privacy and safety, in this case, more privacy, in these cases would have meant much more security for all these people whose information was disclosed by Google, because Google was duped into believing that those requests were coming from law enforcement. So if there had been more procedures and strict regulations about when actually the government can issue these requests, and Google can say, oh, well, this is alleged request that was issued, this alleged warrant that was issued in these terms and blah, 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 this wouldn't have happened. But because it's so easy for this relationship between law enforcement and the private companies to kind of like get information, these companies get duped, and all this information ends up in private actors, so in bad actors. So in this case, more privacy will be more security, not less.
So in regards to that point, Emilio, I would actually say there's this presumption that it's very easy for law enforcement, presumably as long as they're utilizing a warrant or a court order, for them to be able to access this information from these third-party providers. I was a prosecutor for 9 years, and I specifically assisted with the FBI and the U.S. Attorney's Office, actually both in Boston. And then I was a prosecutor in Boston and then in Pennsylvania. It is not easy to get information from these third-party providers. And very frequently, when you have larger providers, such as Meta or Google, Microsoft, they will frequently push back. And it will come to two different points. One, for the longest period of time, they didn't want to actually let us know how much information they were actually keeping on all of their different customers, which is concerning in and of itself. But then, as these companies have become so much larger and they have all of these different employees who are responsive and responsible for answering this information, they'll say, we don't have that, or we don't carry that information. And it actually is very concerning to me as an attorney that we have people who are responding to legal process, not actually knowing all the information that these companies are actually keeping when it's specifically listed within their terms of service, or even when they provide that information in and of itself. But not to get too far afield from the actual question, and I actually will go back to Woody in that regard. I do think it's somewhat of a false dichotomy. And I also think we have to sort of look and see what the expectations of privacy are and how the Fourth Amendment has evolved and what specifically we have to look at in that capacity, because the average American has a very different expectation of privacy than they did previously. Now, there are absolutely, as Emiliano put out there are people who will happily put all of their information out on Facebook. We have plenty of influencers who are comfortable with sharing all of that information out there. But for the average American, even if they're comfortable sharing that within those closed circles, what is the additional information that is specifically being kept on them by these companies? And I think we need to have a much better understanding of that, regardless of whether it is the public sector or the private sector, because when you start gathering and accumulating all of that information, really getting a full detailed picture of who this person is, and when you consider the fact that a lot of these larger companies now essentially have dossiers on most Americans, that's very concerning. And even if law enforcement does access that information, they absolutely should be doing it through a warrant. And I think that SCOTUS and a lot of the decisions that have been pushing towards that, especially in regards to geofencing and historical cell site information, are all moving in that regard. And I believe, and at least the way that our organization teaches it, that always should be done with a warrant. That is really, really invasive when you start examining it through the mosaic theory.
Yeah,
that's.
Oh, go ahead.
No, go, Woody.
No, I agree. There was something I heard of. I can't remember. Apologies, I can't remember what company it was, but they were being deposed and under questioning, they said, "Where is this information stored?" And the engineers were like, "Oh, we don't know where it's stored, nor do we know sort of where it goes." And I agree. That's not great. Overall, one of the things that I'll just add to all of that, and I agree, it's really heartening to see that there's sort of greater recognition around the role of this sort of substantive privacy rules and the third-party doctrine coming under increased skepticism and requiring warrants for all sorts of searches. One of the things that I'll just add to our discussion is I've come to believe that the reasonable expectations of privacy test just generally is a really bad test, and it doesn't serve us overall for multiple different reasons, to not the least of which is sort of who knows what is reasonable under the circumstances, which we spent a lot of time talking about and we'll have to continue to talk about, but also because I think that when we tether our privacy rules to the expectations of people, we sort of implicitly buy into the idea that these expectations are going to get eroded over time. In some research that I've recently done with Evan Selinger and Joanna Gunawin about the way in which privacy law normalizes surveillance, the fact that we've enshrined the sort of expectations as the way in which we set thresholds as to what you can do and what you can't, it almost ensures that over time, through this small sort of deployment of Amazon Ring cameras here and there, and RoboCop, Nightscope robots, roving down the street, and CCTV cameras, that almost without fail, we're going to become used to being watched in all different sorts of ways, and not really have an opportunity along this path to ask, is this sort of ultimately something that we think is good? And so I'd love for us to think about reorienting our privacy rules more around relational obligations and abuses of power, rather than a little more of what I think is ultimately kind of long-term corrosive test.
Thank you, Woody. Yeah, and I would hear that's that I personally like this theory of privacy and as contextual integrity, right, from Helen Nissenbaum, that kind of like sees privacy more kind of like a context issue, where we sometimes are we want some people to know some information about us, but we don't want other people to know that information about us, depending on our relationship with that person, that people. So that has to be taken into account. And what I also wanted to mention now, I forgot, but yeah, that's all.
Awesome, guys. Just for Jill, what are the potential benefits of passing comprehensive federal privacy and security legislation in this context that we kind of just was discussing?
Well, honestly, there will be a standardization. So everyone will have the same criteria to jump through to get the information that they want access to. I did want to make a comment, though, about Emiliano's talking about the Google giving, information. I worked investigations for years. I had to go to the ends of the earth to get information. Even when I had a warrant, I had to show multiple reasons why I needed that warrant and then take it to the third party source that I was trying to get the data from. And I still got pushback, or no, we don't have that, or, oh, I have to speak to this person. And I mean, we had warrants in hand, working with intelligence, working with detective bureaus. So it is not as easy. I mean, it could have been jurisdictional because I work in New York State, but it was really challenging. And sometimes it would delay investigations for weeks because we couldn't get the information we needed in real time. So I did want to just bring that up because I know people watch a lot of TV and it's like in an hour show, they get everything that they need to find the bad guy. People think it's like that and it's not. But again, if we had some kind of framework where there were specific rules in place, specific thresholds that had to be met in order for law enforcement to get that data, it would not only make it standardized, but it would also improve people's their comfort level with the government and private entities maintaining this information.
Yeah, thank you for that. Yes, I totally agree. And I think that what you're mentioning and what Teresa mentioned before is basically another consequence of the lawlessness, right? There's basically no law, so there's no law regulating these issues. So maybe an office from Meta or Google are like more pro law enforcement, so they give all the information to law enforcement. Maybe some of them are not. Instead, that's why we need strict guidelines and strict laws and regulations that they can follow, because if not, this happens, right? What you were mentioning, basically they don't answer requests, they don't answer warrants, and we want them to answer a warrant, right? Because that's issue with probable cause, right? Like we want them to answer those warrants. We don't want them to answer like a simple request from someone that's duping, that's someone that's pretending to be a law enforcement officer. And the best way to do that is basically to make a law, a federal standardized law, a standard law, where all the across the board, all the companies have to comply in the same way with this law and with any kind of requirement that the government does.
And kind of moving along, we're talking about a comprehensive federal, privacy and security standard, and I'll refer to the American Data Privacy Protection Act as ADPPA, just for clarity. We saw a few areas where law enforcement was implicated in ADPPA from last Congress. Let's explore a few of those areas. To begin with, the ADPPA or ADPPA regulated third-party data collection entities that indirectly collect cover data from individuals, more commonly known as data brokers. Woody or Emiliano, if you could elaborate on what are the concerns with not regulating third-party data collection?
I got started. Yeah, I thought you said ECPA, and I was like, ECPA. That's like ECPA, which like it's a law that is like very old. It's like 1986. So yeah, but like ADPPA. So yeah, I think that there is a huge risk in not regulating these data brokers, right? I think that a big part of privacy harms happen because these data brokers collect all these pieces of information from different companies and aggregated, right? Making this even more harmful. Teresa was mentioning before, and I totally agree that it's bad that companies have dossiers about American people. But and I also think that these dossiers are kind of like multiplied and exponentially more harmful when they are in power of data brokers, because they get the dossier from Meta, they get the dossier from all the, I don't want to mention the companies, but they get like all these data points from like different companies that provide different kind of like service, and so they collect different different information. For example, we have like dating apps, right, where people kind of like give information about like their dating preferences. Then we have maybe one of these period tracking apps, right, where individuals kind of like input their period tracking data, and then we have like another apps that do the other things. But if a data broker can actually aggregate all these data points, that dossier that Teresa was mentioning, it can be even more harmful, right? That's why I think that data brokers have to be regulated. In any meaning privacy regulation, without data brokers, I would say that it's not a meaningful privacy regulation. Like a privacy regulation must have provisions about third-party access to information, because those are third parties. They're not private relationship that a person is establishing with a company through an app. So that transfer of information should be extremely limited, and even sometimes it should be like banned. I think, like for biometric information, for location information, especially now where we are seeing all these issues surrounding healthcare and the sick of abortion, right? So location information is a very important, a very revealing data point that people will want, and people want actually to remain very, very private. So in that case, I think that maybe we should talk about banning the sale of location data, right? Like companies should not be able to put in the market your location information, my location information, everyone's location information, because that's very, very private. We have seen this with Carpeton. Not even the government needs a warrant to access us location information. Why would a private company, a data broker, be able to buy this information in the open market? Also, by the way, the market is a billionaire market. So I think that we should start talking about these issues, because this information is very revealing about our preference, about our political activities, for our civil rights and our civil liberties. We need to be able to be in a place where we don't want other people to know, just not because we don't have something to hide, right? But because we just don't want like people to know. I don't want people to know where am I all the time, and I don't think that anyone here wants someone to know where they were this whole weekend, right? So I think we have to start thinking about these issues really seriously and talking about like even out loud, like even banning them.
And to that, I guess there's a perfect follow-up question to that for Teresa. Some data brokers collect geolocation data and data that can predict an individual's future behavior, while others do not collect that type of data, but do collect publicly available information to confirm an individual's identity, which can help prevent fraud and other types of crime. Should the ADPPA take a more nuanced approach to which entities fall under a third-party collecting entity by the type of data they collect or the purpose it will serve?
Absolutely. I really do believe there needs to be a more nuanced look in regards to data brokers, because there are a wide variety of data brokers, and there are some that have existed for, as long as there have been records on the internet. And there are some major ones that are generally utilized by a lot of different police departments, because unfortunately, and Jill can probably speak to this as well, that right now there is not a single comprehensive database that law enforcement can utilize to find information in regards to addresses or phone numbers or email addresses. And that can become very, very difficult, despite the fact that this information can be even just part of regular property records or things that are in fact publicly available. We even run into the issue that for a lot of states, there is not a comprehensive way to look at one individual's criminal record, because we don't have a unified criminal record system. And actually, there are lots of even various different services. So for example, children, youth families, or teachers or schools or daycare providers where they don't necessarily have access to that information, but they utilize that for the background check purposes. So that way they can ensure that the individuals that are being hired into this area are going to be safe and they don't have a criminal record. So again, and that's very different in my mind than the other companies that are out there, the data broker companies that I would say are more in the ad tech field, where really they are trying to compile as much information in regards to one single person. So absolutely, I think there are different tiers, and to consider that all data brokers are the same, or that they are dealing in the same information, I don't think that's necessarily accurate. And I think the ADPPA is trying to sort of tackle that with the specific uses of the large data holders. So those who make more than $250 million a year or process more than $5 million individuals' data information. But even then, there are different categories and they're used for different purposes. And to treat them all the same, it really does a disservice to companies that I think are trying to serve a legitimate purpose, and also for law enforcement agencies who, because of a system that is very, very fractioned, it prohibits them from being able to do a significant in-depth investigation, and they've had to go to the private side in order to accomplish it.
I have a question for Jill. While ADPPA progressed last Congress, the National Center for Missing and Exploited Children was exempted as a covered entity and in other areas. Do you think this should be broadened to other entities that might serve a similar purpose?
So we talked about them before, National Center for Missing and Exploited Children. Their work is very purposeful. They have a mission and they serve as an aid to law enforcement in resolving thousands of missing and exploited children every single year. So looking at it like that, the purpose and the mission and the reason in which that they're seeking this data is to bring children home to their families, help trafficking victims. That's it. That's all they're doing. So other agencies or organizations that are functioning like that with a specific purpose that is not looking for the data for misuse or for any kind of malice reasons, I do see us being able to come up with a very purposeful, list of organizations that should be exempted from certain regulations. That's just my personal opinion. Again, I'm always thinking of it through that public safety lens, and going back to the earlier conversation, we should never sacrifice privacy or civil liberties for public safety. They should be a balanced approach to both. But when you have an organization whose sheer mission is to just find these children and bring them home to their families, I don't see any issue with giving them the data that they need to do that job.
This either Woody or Emiliano, ADPPA revolves around permissible purpose for collecting data, which include detecting illegal activity. Illegal activity was defined as acts that directly harm, but some say that this would leave out crimes that indirectly harm, like ransomware. Is this a valid distinction, and how should legislation consider it?
Yeah, this is a tough one. I think that the logic behind limiting it to direct harm is when you talk about indirect harm, that's basically everything, possibly, depending on also how you describe harm. And so you've basically got an exception that swallows the rule there. There may be a way to thread the needle in that you could limit it to direct harm in the way that it's explicitly defines, and then list specific kinds of crimes that indirectly harm, like ransomware or money laundering or whatever it is that you specifically had in mind, and you have a closed sort of loop rather than an open-ended one that will then sort of still keep the meaningful protections in place while accommodating, understanding that there may be some reasons why you would want to get additional permissible purposes. I really actually liked the way in which the ADPPA imposed its the duty of loyalty data minimization requirement, which is to have a data minimization linked to specific purposes rather than allowing you to state any purpose in advance and then sort of justify it post hoc.
And I do want to leave some time for questions from the audience. So I'll get to this last question, and then I'll ask some audience questions. So the ADPPA has a do not collect registry for data brokers to not collect personal information with a way to delete info as well. How can the right balance be struck between allowing individuals to delete their investigations or to delete their data and preventing bad actors from evading law enforcement investigations? And Emiliano, if you want to take that one.
Yeah, sure. Thank you for that. So I think that the ADPPA currently has an exception for companies to deny, right, these requests to they actually have this like broad exclusion where companies can deny the request to exercise these like traditional privacy rights, the correction, deletion, access, right? If they think that there is illegal activity or unlawful activity or like a harm to someone, or like someone is getting threatened, bodily threatened or something. But I think that the right to delete is a very important right? It's a core privacy right. And I think that everyone should have the right to delete the information that they gave to someone. Like as a rule of thumb, I think that should be the case, unless that other person has another legitimate interest to keep the data, which in this case could be right, assist in an investigation regarding a felony or a crime that's happening. But I think that we cannot. I think that carving an exception in the right to delete will become carving another type of exception that is not the one that I mentioned before, and that's in ADPPA, can be tricky for companies. I think that for these cases, we should not discuss the right to delete. We should discuss what companies are doing to prevent bad actors from using their platforms, right? Because I think that's a previous step that we take for granted. We are taking for granted that these bad actors can access these platforms, right? Well, why? These platforms should have in place guardrails and should have in place mechanisms to prevent these companies being used by bad actors, for example, in case of children, right, to approach children, right? That's why the ADPPA has in these like different standards of knowledge, right, where the high social media covered and the high social, what's the definition? High social media, high data cover social media companies, like for these like big social media companies, where like the standard of knowledge for them is a very lighter standard than for other companies, right? Because if you are providing this extremely popular and this extremely big social media network that children access, right, and that also bad actors access, well, you have to make sure that these bad actors are not using this platform in a way that you don't intend it to. But sometimes these companies don't do this. So I think that we should take a step back and kind of like regulate that. Tell them, okay, look, if you are going to use these bad actors, if you're not going to prevent these bad actors from using these companies, well, you have these penalties, you will have this lower standard of this lower standard for knowledge or for other types of like legal standards, right? So I think that we should also look into that because we shouldn't assume that bad actors can just have like freely access these platforms. We have to see why they're accessing these platforms and what are the companies that own these platforms doing to prevent them from doing so. Thank you.
As you kind of just mentioned about the actual knowledge, entities can deny this request under certain circumstances for those that were convicted of a crime related to sexual exploitation of a child, but they need the actual knowledge a crime was committed. Jill, your experience in investigations, and also Teresa, if you want to chime in quickly, is this practical or should the denial basis be expanded?
I'll be quick about it, but it's really an actual crime is a very, very high threshold that doesn't take into consideration when you need to use this for investigatory purposes. So at that point, you might have a reasonable suspicion that someone did something, or you're investigating something to get to that level of where you could make the arrest for the actual crime being committed. But it's not always practical to just rely on, oh, an actual offense had to have been done in this case. I'm going to give it to Teresa because I know that we're running low on time.
To be perfectly frank, I just think that the terminology in terms of actual knowledge is just another way to give a lot of these corporations sort of an out in regards to either deleting certain information or not turning that information over later on. To reiterate, Jill, it is an incredibly high standard, and it is a high standard that has been determined by the courts. I don't think it should be left up to individual companies.
And I will give one of these audience questions from Jasmine Tran. She asks, what does it look like in practice to reorient privacy around relational dynamics? I believe that was, doesn't say direct to, but I want to say Woody.
Oh, yeah, sure. So the short of it is that the more exposed you are in a relationship of trust, when a company asks you, hey, give us your data, give us your attention, give us your clicks and eyeballs and time, the more exposed you are, the greater responsibility you have. I'm thinking of the borrowing from the law of information fiduciaries and the duty of loyalty that have been proposed by me and a couple of other scholars. And this actually has manifested a bit in the ADPPA. You have your general rule, and then you've got specific rules around data minimization, specific rules around targeting, safeguards and confidentiality, rules against manipulation, and actually rules against mediation, like Emiliano was talking about. And so I think it's very important that we reorient away from sort of general reasonable expectations of privacy towards these relationships of trust, because that typifies, I think, the modern experience. That, of course, importantly leaves out data brokers, because they don't have a relationship at all with individuals, which is why I would also agree with Emiliano, and I think everybody, that it's really important to include data brokers in national legislation, with equally robust rules, but justified under a different theory. The theory of relational protection is that companies invite that trust, and they should be bound to keep it when they do.
And there's a lot of great questions, but because we don't have a lot of time to get to all of them, I think this one's a really great one to end it. It's, what can we do to get ADPPA across the finish line? It seems like it has benefits to law enforcement and privacy. Compromise seems important. And I'll open that to the entire panel.
I don't. I really don't know. That's like a tricky question. Like, I'm not in the head of the members of the Congress or senators, but I think it's there were like a lot of interests, right, going around. Well, here we have like, we have like the privacy interest, we have law enforcement interest, we also have the private companies interest, right? When private companies believe in self-regulation, which I don't believe in, and companies are very powerful, and so I think that kind of like all the planets have to align to have a federal privacy legislation. Yeah.
I've got a theory, which is that if a state passes an incredibly robust privacy law that's nothing like the CCPA, I think the ADPPA will become significantly more attractive at the federal level, precisely for consistency purposes. But I think the other thing to focus on, I mean, in truth, is to focus on the fact that the ADPPA actually, I think it's not the perfect privacy law that I would have picked. And I don't think it's the perfect privacy law that a lot of people would have picked, but it does do a lot of things, I think, relatively well. And to focus on that, and to keep focusing on that, and then to highlight the fact that the longer we wait, the harder it becomes, might hopefully help us.
And Teresa, you're
Just a few Yeah, just a few ideas. First, I think there's a lot of concerns in regards to the preemption of the various different state laws. Once again, if we're under the presumption that the federal law should be the floor, not the ceiling. So I really think we need to be a little bit more considerate in regards to how that preemption is going to work and how we end up creating a unified basis to address all these different issues. I also think that there's a lot of concern in regards to direct harm and the actual knowledge where it's too ambiguous, and I don't think there's going to be a whole lot of movement. And I think a lot of law enforcement is going to continue to be very concerned about it when you're leaving that in the hands of these various different companies, and it also just causes a number of different issues. So frankly, even though I think there are some great ideas, specifically in like Section 230 in terms of individual data ownership, and also Section 206 in terms of some of the exemptions that they have, I don't think it's thought through all the way. And I think there's a bit too much of a demonization on what's in terms of the technology versus the utilization that can happen, how it needs to be a balance. Maybe there needs to be more of a focus in terms of regulation of individual private purchase of certain data sets or something else along those lines.
Thank you. And I'm going to give one last question, if you can answer in 30 seconds, Emiliano. People have the right to know when law enforcement relies on facial recognition technology and other data-driven services when securing a warrant?
I think that yes, I mean, people should have the right to contest any piece of evidence that's used against them, right? Pursuant to like the due process rights and the Sixth Amendment. So basically, these new automated services will become witnesses against the people. So I think that definitely should have access. They should, of course, they should have knowledge that this technology is using, but they also should have access to the system itself, right? Because we want public defenders and defenders in trials to test this technology, to see how this technology works, to see how this technology was trained, to see how this technology, how accurate this technology is. So I think it's essential for people to know when this technology is used against them. Thank you.
Awesome. Well, thanks for joining us today for this enlightening and thought-provoking discussion. We hope that you found the insights shared by our panelists to be valuable and informative. We appreciate their expertise and contributions to this event. We look forward to future opportunities to continue to explore data privacy and security. If the R Street cyber team could be a resource to you, please feel free to reach out to me or Brandon Pugh. Thanks you once again and have a great day. Thank you, everyone.